Hi, very good morning. This is a Supreme Court judgment on arbitration. Dushyant Janbandhu versus Hyundai Auto Ever India Private Limited. Very, very interesting judgment. First, let us see some facts. The dates are very important, so I will quickly give the dates. 15/3/19, the uh, petitioner or the appellant named Dushyant Janbandhu. So we will call him as appellant. He was appointed as assistant manager. 23 3/20 to 6/1/21. This was COVID period. So the company Hyundai asked him to work from home. Then somewhere during August 20, Hyundai asked the appellant to attend office, come to office. Like the army calling the soldiers, they called him back to office. He did not attend the office. He refused to come to the office. It was a COVID situation. 4/9/20, show cause notice was issued to him for his absence. 25/11/20, a charge memo was issued related to non-cooperation by the employee, that is the appellant, and absence from duty. Here it is very important to note that there was no allegation with regard to any non-disclosure obligation by the employee. Then 21/1/21, order for termination was issued. Again, in that order, there was no reference to the non-disclosure obligation by the employee. 29/5/21, during pendency of the disciplinary action, the appellant issued a legal notice for payment of wages under the Payment of Wages Act. He filed a petition to the authorities under the Payment of Wages Act. Hyundai replied and stated that the dispute should be referred to arbitration. Then Hyundai did one more thing. It appointed arbitrator unilaterally. They appointed on their own on 29/5/21. Then uh, appellant, he filed an application to the arbitrator to rule on his competence. He said, you are not eligible to be appointed as arbitrator, so please first rule on your competence. Then 1/5/22, arbitrator held, this is very important, arbitrator held appointment is not valid. It is not in consonance with section 11 of the act, and hence held that he is not competent to arbitrate the dispute. 3/3/22, an application under section 8 was filed by the Hyundai asking the authority to refer the matter to arbitration. Because if you see, just two lines back, I said the employee filed an application before the authority saying that you have to pay me the wages, asking the direct the Hyundai to pay the wages. So they moved an application. The Hyundai moved an application under Section 8, saying that this has to be referred to arbitration. Then 21/1/2021, appellant questioned the order of termination before the industrial tribunal, and the same was pending. Hyundai then approached the High Court for appointment of arbitrator. High Court, surprisingly, they appointed arbitrator. So these are the facts. Question is, first, the the employee was asked to go on to work from home. Then he was called back. He did not attend the office. So show cause notice was issued. You are refusing to attend the office. Disciplinary action will be taken. No reference to this non-disclosure obligation clause either in the notice or in the order or in the inquiry report. Employee went and filed for payment of wages before the authority under the Payment of Wages Act. Then company moved an application under Section 8. In the meantime, they appointed arbitrator. Arbitrator also said, I don't have competence to arbitrate the dispute. Everything happened. Now, the company went to High Court. High Court appointed an arbitrator. This was challenged before the Supreme Court. Supreme Court noted that violation of non-disclosure obligation was not part of the notice, show cause notice, charge memo, or termination letter. That is the first thing which the Supreme Court noted. Then uh, the everything related to all these three things related to payment of wages and validity of termination. Then appellant, the employee, approached the authority under the Payment of Wages Act much before order of termination. So the authority, whoever is the authority under the Payment of Wages Act, he can only exercise jurisdiction to the exclusion of civil court. And these disputes are not arbitrable as per section 22 of the Payment of Wages Act. Further, the jurisdiction of industrial court is also to the exclusion of civil court and is also not arbitrable. So Supreme Court clearly says the dispute is with regard to Payment of Wages Act and with regard to validity of termination. These two disputes are not arbitrable and it is subject to the exclusive jurisdiction of the authority under the Payment of Wages Act. Supreme Court held that Hyundai was clearly threatening the appellant, that is the employee, for approaching the authorities under the Payment of Wages Act. There is no basis for invoking clause 19 because clause 19 was never invoked in the show cause notice, nor quoted in the charge memo, nor quoted in the termination order. So Supreme Court says this is only a threatening approach of the Hyundai to threaten its employee. Then Supreme Court says section 11(6) of the Arbitration Act petition has two phases in this case. One is dispute pending before the authority under the Payment of Wages Act and the uh, question related to termination of the employee, which is not arbitrable. The second facet is non-disclosure obligation, which is not in the show cause notice or in the charge memo or in the termination order. Again, that means it is not existent till the last this thing, Supreme Court, High Court, it was not in existence. So Supreme Court dismissed the case, but they have imposed a cost of heavy cost of rupees 5 lakhs on the Hyundai, on the employer. There is an interesting this thing in my case also. Just I want to refer it. There was one clerk which was employed in a good company. I won't say it is a multinational company. I think it's a good company, maybe a multinational. He was earning around 30,000 rupees. What happened was he served for 2 years or so. Then he got a good opportunity. He resigned the job and then joined another company. Maybe the other company was in the same line of business or similar line of business. Then surprisingly, a legal notice was issued, that too by a very, very big law firm. I was really shocked and surprised to see that a big law firm like that can issue a show cause notice saying violation of this confidentiality agreement, non-disclosure agreement, then joining another competitor company, etc., for a clerk who was earning 30,000 rupees per month. So I got really annoyed and upset also because even if the client, sometimes the client may be, the employer may be saying, no, no, sir, I want to file a case, I want to issue notice and threaten my employees. But as a big law firm, even if he is my best client, the lawyer should have advised that the company, no, no, this is a case of this nature, so this will not be sustained in a court. But finally, after I gave a strong reply, then they dropped the proceedings against the employee. Even though the amount is small, I wanted to help that fellow. So I just drafted a reply and sent it. They dropped and saying some other reason. In Tamil, they used to say, கீழே விழுந்தாலும் மீசையில் மண் ஓட்டலை. That means even if you fall down, you will say, no, no, there is no sand in my bush. That is, you don't want to show it to others that I lost the case. So they withdrew the notice. The point which I want to make is, I'm not saying all the employees are good. I'm not saying all the employers are bad. Uh, but the point is, whenever there are disputes, there could be disputes, employee, employer, husband and wife, naturally disputes will be there. But somebody has to look into that dispute and advise the client. Sorry to say, I'm not criticizing the present advocates for the company, Hyundai. I'm only saying generally, as a general statement, I'm saying better to tell the client on his face, boss, you don't have a case. There is nothing wrong because you are a doctor. A doctor has to say the truth. Is my view. That is my view. Thank you very much. Have a great day.